Good morning and welcome. The good news is I received a call from President Obama this morning, and due to the sequestration, the dean's remarks will be cut by 10%. But everyone will be able to use that time. Welcome to McGeorge School of Law. If you haven't been here before, we're very proud to host this great group of speakers and participants. Our Global Center for Business and Development, which is co-directed by Linda Carter and Frank Gevurtz, has done a lot of great programming over the years, and this looks like it will be keeping in that line of really providing timely, excellent programming on issues of interest to scholars around the world. And I thank you for participating and wish I could stay for the proceedings, but I won't be able to. We're also partnering this time with the Max Planck Institute Luxembourg for International European and Regulatory Procedural Law, and I met Marco last night for the first time, and he and Frank have set up a dual set of conferences, I believe. So there will be a conference in Luxembourg later this month. So I think that's a great development, and thank you for participating, Marco. I'd like to thank the staff. We have an incredible events staff. I hope you appreciate the benefit of all their hard work in setting things up. I hope you enjoy your time on campus. Please take a few minutes when you're on break to enjoy the Northern California weather. Vivian was trying to get out of a snowy Pittsburgh, so she's especially happy to be here. Without further ado, I'd like to turn the podium over to Frank Gevurtz, who is an incredible force of nature. One of the great things about academia, I think, is the freedom to do individual projects, and we all enjoy doing our work. But one of the great benefits in academia is when you can bring talented individuals together and have them focus on a common theme. And I think Frank, during his whole career, has been very adept at doing just that, and this is another example of his work. So without further ado, I give you Frank Gevurtz and wish you a very good conference. Thank you.
My thanks for attending and for the participants for this venture. This started actually with a number of emails back and forth between myself and Marco, where we discovered we were both interested in the Morrison case and decided to set off on this two-part venture. One of these days, we hope that the technology as well as the time frame will allow for simultaneous conferences between Luxembourg and the United States with holographic images for both sides to see what's going on in the other. But that'll have to wait to a galaxy far, far away and long, long ago. My job this morning is to provide background for the rest of the speakers because this particular conference is looking at the aftermath of a particular decision. And we needed somebody to brief the case, and so I picked on somebody in the back row, and it turned out to be, ooh, you Mr. Gevurtz. And so Mr. Gevurtz got called on to brief the case and to give background from which the rest of the speakers can draw. And I've done a little bit of a PowerPoint, which we don't expect out of our students, but maybe we should in the future when they brief a case. So let's start with looking at Morrison versus National Australia Bank. And on the PowerPoint, I've listed the plaintiffs are a number of Australians. I've abbreviated that, hopefully not to the offense of anybody here who's from Australia. The defendant is an Australian bank. And the claim is that they bought stock, the plaintiffs bought stock in Australia on an Australia exchange based upon false information provided by the bank. The bank described the prospects for a certain subsidiary in the mortgage servicing business as being more rosy than they turned out to be. And when the true results came out, the stock plummeted and we have a lawsuit. So that's the basic facts of the situation here. Now, you're going to say, why on earth do we care about some Australians suing an Australian bank after they bought stock in an Australian stock exchange? I realize this is the Global Center, and we're talking about global business and development, but if we wanted to simply pick on a case involving something, maybe we should go with a bigger economy like China or something like that. Why do we care about these Australians? Well, it turns out that we're dealing with a Supreme Court of the United States case. Morrison is decided by the United States Supreme Court. And that's because these Australians decided to file a class action lawsuit in the district court in the United States. And their claim for being there is that this action by the Australian bank was a violation of U.S. securities law, Section 10b of the Securities Exchange Act and Rule 10b-5 promulgated under the Act, which makes it unlawful to use the mails or any means of interstate commerce to make a false or misleading statement in connection with the purchase or sale of a security. So that's why we care. This Australian lawsuit has ended up over here. Australian only in the sense of who the parties are. Now, why is it here, not in Australia? We blame Florida again. We like to blame Florida for lots of things. We had a certain administration for 8 years. We blame Florida for that too. But in this case, we blame Florida because the Australian bank misstatements involved a subsidiary, a company it purchased, which was a Florida mortgage servicing company. And that Florida mortgage servicing company had inflated its prospects, and various false statements were made, many of which were in Florida, because they weren't going to travel to Australia to talk, Florida being kind of pleasant. So that's why it's here. Now, a number of you might have said, gee, this sounds like a jurisdiction case. And as a matter of fact, we're supposed to have a lot of civil procedure students this morning here, and a lot of them would have jumped up and said, civil procedure, jurisdiction. In my Yoda fashion, jurisdiction not. The district court says jurisdiction not, and the Supreme Court says jurisdiction not, but the reason they say jurisdiction not is different. The district court says, we don't have jurisdiction to hear this case. The Supreme Court says, this isn't about jurisdiction at all. Not discussed. Let's not talk about jurisdiction. Because that confusion about jurisdiction then gets spread over and follows this case in its aftermath, I think it's important to clarify a little bit about jurisdiction here. And it turns out that there are about 3 different meanings of jurisdiction, all getting bollocksed up here in this case. First, the jurisdiction of a court to hear a case, which turns out to have 2 parts. Personal jurisdiction, which would be near and dear to all civil procedure students' hearts, which is definitely has nothing to do with this case because the Australian National Bank does a variety of business in the United States. But also because this is in federal court subject matter jurisdiction. Federal courts must have in the United States specific subjects that they can hear, such as diversity actions and so on. Otherwise, they can't hear the case. Statutory jurisdictional language. So, for example, in teaching securities law, we'll often refer to the jurisdictional language of the Securities Act. That, in this instance, is the specific language which refers to the use of the mails or means of interstate commerce to do the prohibited act. And that's there in order to be constitutional because in 1789 it didn't occur to the drafters of the Constitution that the federal government needed to regulate securities markets, probably because there weren't any in the United States at the time. So that everybody refers to as the jurisdictional language of the statute, what it takes, where the action must be in order to violate the statute. And finally, we come to yet a third concept of jurisdiction, which is referred to in a restatement as jurisdiction to prescribe or prescriptive jurisdiction. And that refers to concepts under international law or dealing with comedy about when it is appropriate for a nation to attempt to apply its laws to conduct. There must be a sufficient nexus to the nation. And there are 5 concepts I want to introduce which may become up relevant later as we talk about application of U.S. laws in other contexts. The 5 traditional principles of prescriptive jurisdiction being territoriality, where the actions occur, nationality, particularly of the defendant, who you're trying to regulate, the passive personality principle, which is rather controversial, which is the nationality of the victim, essentially, of the conduct. The protective principle, which is essentially protecting national security interests. And finally, universal, that's piracy and genocide, the idea that any nation can prosecute that action no matter where it takes place. So that's the sort of principles, and the idea is that nations that go beyond those principles would act contravene either international law or principles of comity.
Frank?
Yeah?
Are you including effects under territoriality?
Yes. I am. That's going to come back to that.
Are you including both effects that are elements of the effect?
Coming back to that.
Okay.
Now, the reason I raised this whole discussion of jurisdiction, and I have the heading, sorry, I didn't get the message, is because Congress attempted to half overrule the Morrison case. The statutory language is here, and in fact, I will see if I can use my little laser here, which stuck in. Let's see if that works. Ooh, I want to be techie here. Nope, that's not the laser. That's worthless. Oh, well, that's what you get in the free stuff at the AALS convention. Now, if you look at the language jurisdiction, essentially what Congress decided to do in the Dodd-Frank Act, and they had about a day to draft this between when the case came down and when they had to move this thing out, was to overrule for public prosecutions, but not for civil actions. The Morrison rule, but they basically phrased it in terms of the courts having jurisdiction to hear the case, which means this whole thing might be irrelevant, because what the Morrison case said is this is not about jurisdiction. What had happened in the lower courts, and in prior Supreme Court cases to be candid, was that the idea of prescriptive jurisdiction in terms of the jurisdictional language of the statute, and subject matter jurisdiction had all been put together into a big bollocks ball, and so the cases had been dismissed for lack of subject matter jurisdiction, and the Supreme Court in Morrison said that's just wrong. It's a securities prosecution. The statute says that federal courts have exclusive jurisdiction to hear cases brought under securities law, whether or not this conduct is outside the reach of the securities law because it takes place elsewhere is a interpretation of the statute question. It's not jurisdiction. And unfortunately, the drafters of the statute didn't read the case. And so we have perhaps an idle act, but also we have to be careful when you start talking about jurisdiction, which is, I've seen in a number of conferences that people start talking about jurisdiction and it creates a mess. So I just wanted to try to, as people say, isn't this about jurisdiction? Clarify a little bit. Now, this is really about how to interpret a statute. And so I have how to interpret a statute by AS, that stands for Anthony Scalia, the drafter of the majority opinion. By the way, he's trying to sell a book about how to interpret statutes. This is all you need to know so you don't have to buy the book. And the book is emphasizing textualism. Look at the statutory language. Now, the 4 steps he actually applies in interpreting the statute in Morrison, step 1 is ignore the language. Step 2 is be presumptuous. We're going to get to that because that's important to our conversation today. Step 3 is don't read definition sections. Again, that's a repeat of step 1 in a specific case. Don't ignore the language. And finally, step 4 is just make up a rule. So we go through the steps. Jurisdictional language in a statute is there to be ignored. That's Scalia's first point. The statute specifically says use of means of interstate commerce. Now, at first you'd think, what the heck does Australian banks have to do with that? But in fact, the definition of interstate commerce also refers to trade, commerce, transportation, or communication between any foreign country, say Australia, and any state, say Florida. And I suspect during the course of these false statements, somebody communicated between Florida and Australia because that's how the false statements were made. So the jurisdictional language is kind of met, but we ignore that. We simply cite Aramco, and which basically said we ignore it because it's boilerplate. I thought you put contract language boilerplate in there for some purpose, but I guess you're supposed to ignore it. Now, step 2. invoke the presumption against extraterritorial application of U.S. law. And that's something we're going to be spending a great deal of time on during the course of today's conference, because it is that presumption and the question of whether it will apply in other statutes that is going to be fairly critical for our discussion. The idea is that if we don't know what Congress intends, we presume it not to intend to cover things outside the United States. I'm using that term of legal art, things, for a specific reason, which you've already been asked about, and I'm going to come back to. Things outside the U.S., we presume Congress doesn't wish to address. That's the presumption. Now, you can rebut the presumption by looking at the language of the statute to say, yes, Congress did intend to cover things outside the United States. So we go back to the language of the statute, where we cut back to step 3, which is really a variation of step 1. There's actually a provision in the Securities Exchange Act which addresses the reach of the statute outside the United States. And it basically says, and I'm paraphrasing to keep it on a simple slide, the act doesn't reach a person who transacts a business in securities outside the U.S. It talks about on foreign exchanges, but outside the U.S. And Scalia says, aha, that proves my point, that Congress didn't intend to cover things outside. Here's where the principle, always read the definition section, comes to mind. The one thing I learned from Frank Newman's administrative law class back in Berkeley, which is read the definition section. That's what it's there for. Transact business and securities is a term of art referring essentially to brokers and dealers. And so this is not a provision that says we're not going to cover things outside the United States. It's saying, hey, we're not going to cover brokers, because there are lots of provisions in the Act specifically regulating brokers who are transacting business on foreign exchanges. That's what it's there for. Now, what Scalia misses, everybody else kind of realized, is that why would it be necessary for Congress to say we're not going to regulate brokers outside the United States if Congress didn't assume that the statute would apply outside the United States? Oh, well, now you don't read the book, okay? That's what that whole step 1, 2, and 3 is about. Make up a rule. But we don't get to make up a rule without realizing, a slight intermission, that this whole discussion is a big red herring. Is this really a case about extraterritorial application of law at all? At this point, I've got what is a little drawing here. You see the little X, little arrow, then this thing which is supposed to be a fence, and the O. X is a person who shoots a rifle. The fence is the border, and the O is the victim, the classic example of a cross-border crime. Question, where does the murder take place? Where X is, who shoots the rifle, where O is, who gets shot and killed. Which nation prosecutes that action? Now, let's translate that into the facts of this case. National Australia Bank has lied in Florida, shooting the rifle, causing plaintiffs to purchase stock in Australia based on those lies. Victim shot, other side of the border. Question, where does the violation of the statute exist? That's really the issue in the whole case. Effect and action. There may be, obviously, I'm oversimplifying, could use a simple hypothetical, because every conduct could be in a variety of places, effects could be in a variety of places. Answer, let's make up a rule. The place of the transaction, where the stock is bought or sold. It's kind of cool. That's the answer. Now, how do we get there? Which is the why. Well, Scalia gets there because of the presumption against extraterritorial application. He says that answers the question. Now, wait a minute. How can the presumption that we don't mean to regulate things outside the United States tell me where the thing is? To say, is it in the U.S. or not? One possible answer is that the transaction is part of the elements of the wrong. Fraud is not a violation of the section unless it's in connection with the purchase or sale of securities. You must have both fraud and the purchase or sale of security. And if you don't have both, you don't have the violation. And therefore, perhaps what we are saying is that the presumption is that all elements of the wrong must occur within the nation, or else we presume Congress didn't mean to cover it. Problem. Suppose every nation took that approach to regulation, that if all elements of a wrong do not occur within the nation, then we will not regulate it. Well, the implication in securities fraud is obvious. The implication in my cross-border shooting is obvious. X gets off scot-free because neither nation has all the elements of the crime take place within the nation. That's got to be kind of a bit of a problem there. Well, if the answer really isn't the presumption, maybe it's policy. And so we start thinking about policy bases to make this decision. Well, first it's simple. And Scalia did criticize the prior lower court opinions, which talked about where the conduct occurred, where the effects occurred, and then balanced interests of competing nations to figure if there was enough nexus to the United States. And he said, boy, is that complicated and hard to figure out. Let's have simple rules. By the way, for those of you who have taken some conflicts of laws, recognize the difference between the Second Circuit, which is the sort of second restatement approach, sort of interest balancing approach to conflict of laws, and Scalia's simple rule, as in first restatement approach, let's make up a rule. Simple, easy, where the tort occurs, where the contract's made. But there's one little problem. Suppose we had an agreement to purchase or sell security in a transatlantic phone call. Where does the sale occur? Now, there's actually a lower court that says, well, it's where the contract is actually formed. I guess we'd have to listen in on the phone call and figure out who said, I accept. Because whoever got that last little piece there, I guess that side of the Atlantic is the one that, is where the transaction occurs. But this is no longer simple. Policy 2. Who cares about a bunch of Australians anyway? Sorry. Not our problem. And why is it in the U.S. court? Maybe that's our answer. To this, I would compare Judge Friendly, probably the finest judge who never ended up on the U.S. Supreme Court, his approach in a case called Leasco. In a case called Leasco, which Scalia says that's just wrong, a U.S. company was convinced to buy stock in a British company. The first meetings took place in the United States in which there were some misrepresentations. That was followed up by further mailings from England to the United States of accounting documents full of misrepresentations, followed up by a meeting in England with further misrepresentations, at which point they closed the deal and bought the stock. And Friendly says, I think there's enough conduct in the United States to justify U.S. law applying. Now, from a policy standpoint, shouldn't that U.S. investor who's been lied to initially in the United States and convinced to buy this stock be able to sue for violation of U.S. law? Otherwise, suppose you get that mailing typically from Nigeria that tells you if you only invest $5,000, you can have this inheritance or half of it too. And that comes to you as your home on your email, cross borders. Shouldn't U.S. law prohibit that? Well, maybe. I think we have some interest there. Finally, and that's the flip side, maybe the interest is in getting along. Can't we all get along? And in fact, Scalia is responding to a number of nations who had filed a amicus brief that says, you U.S. guys with these class actions and things that violate our notions of what is appropriate in terms of private remedies and discovery and all this sort of thing. It's just terrible. It's bad for our business. And so we should not have this sort of legal imperialism of trying to apply our law and our procedures overseas. And maybe that's what. And there's a concern about getting along. But I would suggest there's a mirror image in terms of getting along. Imagine the world's reaction if one nation were to say, hey, we kind of like it when our citizens send out emails soliciting money based on false representations, and also if they sail out to sea and see some ships, that's happened to go by and builds up the local economy. So I don't think we're going to prosecute that. Now, you people have victims. You can try to prosecute these guys, but we're not going to help it. We're not going to aid. That's called being a Barbary Coast. And I don't think we like that sort of thing. And so the concern is saying, not our problem when people send out fraud from the United States is one that I think if the shoe was on the other foot, we wouldn't like it if other nations did that. So get along works both ways. Now, implications and the roadmap for today. Question 1, panel 1. Where do the Australians go now? Because if the U.S. doesn't want to have these private suits anymore, maybe other nations, maybe the Netherlands, will figure that this is good for them. Question 2, what about other statutes? Is this approach to U.S. law, which is basically one saying we don't want our law to go outside the United States, going to be applied elsewhere? Panel 2, which will deal with that both in terms of specific laws and in terms of general approaches. Finally, question 3. Who polices securities frauds in an increasingly interrelated global securities marketplace? Panel 3. And with that, we'll now introduce panel 1. Okay. Let me first introduce on our panel. We have 3 people to look at comparative, I'm going to use the term class actions, which is too US-centric. Collective actions would be the sort of European terminology. Collective and private actions, because a lot of the undercurrent of Morrison is disagreements between nations about private actions and a feeling that maybe there's some abuse there. And the first of our speakers to provide an overview is Dick Buxbaum of the University of California, Berkeley, Bolt Hall. You have the bios, and to keep us on schedule, I'm going to be short with that. I hope the speakers forgive me, and give you the sort of bottom line about Dick Buxbaum. Dick Buxbaum is a person who carried on the tradition of the University of California, Berkeley, of being a leading institution in comparative law, going back from Ehrensweig and Riesenfeld and Dick Buxbaum. And I'm not sure where it goes now, but it has been a fine tradition, and Dick has been a leader in comparative law, particularly with respect to comparative corporate law field, and the keeper of the flame for the last, there when I was there, so 30, 40 years.
52.
50? No, I didn't want to say that. You seem like a young guy. Okay, and so here's our first speaker. We'll have, following Dick, I'll just introduce everybody. Mark Steinberg of Southern Methodist University is an absolute leader in securities law scholarship in the United States. And very pleased to say the co-author on the most recent book in the Global Issue Series dealing with comparative and transnational securities regulation. You can ask for no better expert in terms of securities law, and also considering its worldwide implications than Mark Steinberg to join us, and we're very pleased. And finally, Winfried van dem... and I can never pronounce Winfried's name in all these years. Van dem... Let you struggle a bit, Frank. That's mean. That's so mean. We just call Winfried Winfried. Is a lawyer, I'm almost slipping out that one, the most prominent Dutch law firm, and there has firsthand knowledge of the goings-on in the Netherlands, which is trying, I suspect, to make a little money on being a home. No, seriously. Why not? For sort of class action settlements worldwide. Winfried is the epitome of the transnational attorney in corporate areas, lately representing the poor victims at Yukos of the Russian government's wrongdoing. And so we have a really distinguished and fine panel to begin the day, and I'll now turn it over to Dick. Thanks.
You know, I have to admit, it's always interesting to me to watch Frank's style at getting at a problem, because somewhere about halfway along it, I begin to realize I'm learning a hell of a lot. You know, because it begins so calmly, well, he's never calm, but I mean, it begins so easily. You know, there's just these basic things and so on. And about, by the time you get to Scalia, you know, I'm scribbling away notes. So thank you for that. It was really a very illuminating way to touch this problem. But I'm going to go backwards quite a bit, or upstream, whatever you want to call it, because Frank and I agreed that before getting into the discussions that are going to be had here, it might be worthwhile to focus on the one aspect of this field, and I'm speaking now of securities more than of the other forms, although even in the ATS field it can have some bearing, namely the implied private cause of action and the significance of that concept in securities law, and especially in the comparative aspects of securities law. So that's going to be my, what is it, 15 minutes or so? Yeah. I'm going to begin as sort of a point of personal privilege. In 1970, I gave an invited lecture the German Federal Supreme Court has a series of lectures they do about 4 a year from academics. And the subject I was asked to talk about was the private cause of action, and specifically the implied tort private cause of action, meaning it was of some interest as the German capital market began to have more than 15 listings, because most of them were in the GmbH category, and as antitrust began to be a serious concern. I should say it fell on deaf ears. The actual audience of these judges was not at all convinced of the beauties of the implied tort cause of action, but I did my best. And the subject matter happened to be securities litigation primarily and antitrust secondarily. Those were the cases. And of course, at least in the cases they wanted to hear about. And in the case of securities regulation, of course, since most US actions involved Rule 10b-5, right, the comparative aspect of that issue really was the development of the prerequisites and limitations of the implied tort doctrine. That was kind of the central feature. Now, I'm quite sure that not only German, which I know a little better, what little I know is mostly about German law, but all civilian legal regimes have some concept of the implied tort cause of action, the judicially created action based on a breach of some regulatory statute that has a defined circle of beneficiaries. And they could calibrate their interpretation of their civil code in jurisprudence. It isn't usually expressed, except in Germany, where it is expressed in 823. They could calibrate their discussion quite readily along the framework that in the United States, for us, always starts with Thayer's seminal article of 1915, 1917. And I'm going to give a quote from that later. So now staying with Rule 10b-5. We're so accustomed to its availability for the private right of action that we've generally focused, as does this conference, already 2 steps forward from there. This conference heavily on the extraterritorial nature, but upstream from the extraterritorial nature of the causes of action is the class action, because 90% of these actions are class actions. And upstream from the class action is the fact that all of this is founded largely on implied causes of action. Right? So I thought it might be more interesting, in a sense, to tease out some of the implications beginning there, rather than already jumping immediately into the other. Now, these doctrinal concepts are more universal, however they are phrased, and it shouldn't be difficult for the U.S. lawyer either to look at these questions comparatively. Take, for example, I'll come back to these things later, the standing limitations that the Supreme Court imposed in blue chip stamps, or the rejection of liability for secondary actors in Central Bank of Denver, Stone Ridge, and Janus Capital. So we can appreciate already ourselves how classic questions of foreseeability, with their effect on the ability to identify a particular class of victim beneficiaries of the statutory norm, affect the scope of these remedies. And already there you can see one thing, that in the United States at least, the fact that 10b-5 requires a willful conduct and not just negligent conduct has a bearing on the definition of the circle of beneficiaries that the statute and the rule were supposed to protect. The cases pretty well say they protect the markets. They protect the entire capital market. They protect all investors. If you go back to Thayer, that's unthinkable. Right? The principal idea there is that your first step is to identify the very particular circle of beneficiaries of the regulatory statute. Right? But of course, he was speaking of negligence. And there are reasons, again, comparative reasons, why in the case of negligence, you want to be a little more careful about the circle of beneficiaries of a regulatory statute. Whereas in the case of the victims of willful conduct, perhaps the circle can be ballooned outward without much harm. So there's my first issue that I wanted to put on the table. As an example of a place where comparative looks at these questions would be relevant as other countries develop their versions of private causes of action, whether implied or express, as the European Union, of course, is doing under the whip of the Council of Ministers and Commission, under directives calling for countries to adopt more of a private cause of action structure for these areas. So, I already have mentioned how the initial presumption of Thayer that conduct was negligent has morphed into our ideas in 10b-5, right, of willful conduct. Now, in one sense, of course, from the standpoint of U.S. jurisprudence on the implied cause of action, this is an a fortiori case. That is to say,